Hello, Mr. Butler. All right, court is calling 2025 CR 02895, 2025 CR 00278, 2026 CR 00405, State versus Marcus Butler. Can I have parties announced?
Second Galloway for the state.
A reporter for Mr. Butler.
And are you Mr. Butler?
Yes, ma'am.
Sorry. Just give me. Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
Yes, sir.
In each cause number, the court will find that the state is in compliance with discovery. And the cause number ending in 405. Do you understand you have a right to have a grand jury be presented with evidence and make a decision on whether or not there's sufficient evidence to hold you over for trial?
Yes, sir.
And do you understand that your attorney has the right to the passage of 2 days from the presentation of the information and 10 days to prepare for trial?
Yes, sir.
And do you understand by entering this plea, you're giving up those rights?
Yes, sir.
And did you intend to give up your rights and waive indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
Yes, sir.
And that cause number, the court will find that the defendant has knowingly and voluntarily waived his right to indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. And the cause number ending in 95. Did you review that indictment with your attorney? Did you understand it?
Yes, ma'am.
And in cause number 80, did you review that indictment with your attorney and did you understand it?
Yes, sir.
And in cause number ending in 05, did you review that the felony information with your attorney and did you understand it?
Yes, sir.
Defense, in each of those indictments and the information, do you waive the reading?
I do.
State, in cause number ending in 95, are you proceeding on the indictment as presented? That's the unauthorized use of a vehicle and theft of property.
That indictment, we are waiting count 1 and proceeding on count 2 and waiting the punishment counts.
No objection.
And in the cause number ending in 80, are you proceeding on the indictment as presented? That's the possession 1 to 4 and unlawful possession of a firearm.
We are waiting count 1 and proceeding on count 2.
Any objection?
No objection. I believe they're waiving the enhancements on that.
I don't have a list of enhancements for this. I just have one page. Are there enhancements?
There-
Okay.
Judge, there is a repeat offender enhancement as we are waiting.
All right, any objection to the waiver? And then in cause number ending in 05, you're proceeding on the information as presented?
We're proceeding on the lesser included offense of assault.
No objection.
All right, Mr. Butler, in each of the cause numbers, did you review the court admonishments and stipulations? I'm sorry, the court admonishments and waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, and cause number ending in 9-5. The state is proceeding on count 2, which is theft of property, 2,500 to 30,000. The range of punishment for that offense is from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. And the cause number ending in 80, the state is proceeding on count 2, unlawful possession of a firearm by a felon as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And the cause number ending in 05, the state is proceeding on the lesser included offense of assault causing bodily injury. That's a Class A misdemeanor. The range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
I did, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, sir.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, sir.
Mr. Butler, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your
Are
Honor.
you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into these plea bargain agreements, you will be deported, denied naturalization, and re-entry into the country. Did you understand?
Yes, I did.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorneys? Did you understand it?
Yes, Your Honor.
And cause number ending in 9-5, according to the plea, the state is proceeding on count 2. They're asking that your punishment be assessed under 1244 at 61 days in the Bexar County Jail. There'd be a $2,000 fine and there are no applications. And the cause number ending in 80, the state is proceeding on count 2. They're asking that your punishment be assessed at 6 years in the prison. There's a $2,000 fine. There are no applications. They're taking in consideration 2025 AL 012255 and 2025 PF 45871. And the cause number ending in 05. State is asking that your punishment be assessed as follows under an assault causing bodily injury to 60 days in the Bexar County Jail. There's a $1,500 fine, no applications. This will run concurrent with 2025 CR 002780, 2025 CR 002895, and there's to be no contact with the complainant. Did you understand that to be your plea in each of the cause numbers?
I do, Your Honor.
Defense, is that the plea?
It is, Judge, just kind of one clarification.
Yes.
The technical one.
No, no.
On the 05 case,
Yes.
because that's going to be a J set, it really doesn't have to run concurrent with any other
Okay.
cases.
All right, if y'all want me to remove that.
As long as the court says J set, it doesn't matter.
All right, so does he have 60 calendar days?
Yes.
Okay. Thank you. State, is that the plea?
That is the agreement, but I did misspeak earlier regarding the cause number ending in 80. It wasn't happening for the incident, so I just want the record cleared up on the following.
All right. The record will so reflect. And each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did, Your Honor.
Counselor, have there been any such motion?
No, yeah.
Then in 2025 CR 002895, how do you plead to count 2?
No question.
And 2025 CR 002780, how do you plead
No
to count
question.
2? And 2026 CR 0004005, how do you plead?
No contest.
To the, I'm sorry, to the lesser included offense of assault bodily injury.
No contest.
State, any evidence to support the defendant's pleas?
State offer states one in attachment to the deed.
No.
All right, and state, have you had a chance to reach out to the complainants?
Yes.
All right, thank you. You may be excused. In each case, Mr. Butler, did you review the document entitled Waiver and Consent for Stipulation of Testimony and Stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
I do, Your Honor.
Do you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And cause number 2026 CR 0004005, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Please, Your Honor.
And that cause number, the court will sentence you to 60 days. In the Bear County Jail, give you credit for any time served. There's a $1,500 fine. Time and money will run concurrently. There's to be no contact with the complainant. LEE. And both parties agree that the judgment will be satisfied in that cause number. Next, we're going to proceed in 2025 CR 002780. And that cause number, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. For the record, the enhancements are waived. Sentence you to a $2,000 fine, time and money to run concurrently. 6 years in the prison. Give you credit for any time served. Take in consideration 2025 AL 012255 and 2025 PF 45871. Is there anything else in that cause number with regards to sentencing?
No, Your Honor.
Let me just make sure it shows in Odyssey that those were taken in consideration. The only ones that won't show up in Odyssey for me is the one that's the AL cause number. As it's getting the case. There we go. All right, for the record, the 2025 PF 45871 case for the court is pulling up as 2026-000418. Is that correct? Let's go off the record for a moment. State, could you check for me 2025 PF 45871 is pulling up as 2026 CR 000418. All right, thank you.
I guess it got indicted at that. Like, get forward on. You say, so I'll read to it right now.
All right, thank you. Okay.
Okay, thank you, Judge.
All right, then the next cause number we're proceeding on is 2025 CR 002895. All right. And this cause number? The court is going to find that there's sufficient evidence to find you guilty under count 2. Court will sentence you to 61 days in the Bexar County Jail. Give you credit for any time served. There's a $2,000 fine. Time and money will run concurrent. Is there anything else with regards to sentencing under that cause number?
No, from defense.
In each of the cause numbers, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because these are plea bargain agreements, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
47 years old.
All right, so if you continue doing what you're doing, you're going to end up spending the rest of your natural life in prison. Do you understand? So you had better get your life together. Otherwise, your life is going to be wasted at the prison. All right, good luck to you.
Today's courtroom looked routine, but it quietly built toward a hard stop for a defendant who thought paperwork would save him. Marcus Butler arrived with multiple cause numbers stacked against him. answered politely, and waived rights as if this were just another box to check. The judge moved methodically, confirming discovery, indictments, waivers, and ranges of punishment. Each "yes, Your Honor" sounded calm, confident, and practiced, but beneath that calm sat a dangerous reality: theft, unlawful possession of a firearm by a felon, and assault, all converging in one hearing. That contrast, routine procedure versus irreversible consequences, set the trap. As pleas were reviewed, the court laid out the stakes with precision. Theft carried jail time, assault carried fines and restrictions, and the firearm charge carried years. The defendant agreed anyway. No objections, no hesitation. The courtroom stayed quiet as the judge explained that the court was not bound to any bargain. It was the kind of warning people hear but rarely feel until it's too late. When the state proceeded on counts and enhancements were addressed, the tone remained professional, almost gentle, masking how final the moment had become. Evidence was stipulated, live testimony waived, and the judge reviewed exhibits. Then the pivot arrived. The court found sufficient evidence and pronounced guilt. Sentencing followed swiftly. 60 days here, 61 days there. Fines added up. Credit for time served. Conditions imposed. And then the heavy one: 6 years in prison for unlawful possession of a firearm by a felon. The air changed. What looked manageable seconds earlier suddenly carried years of consequences that no waiver could undo. The judge ensured the record was clean, clarifying case numbers and considerations, then closed the door on appeals. By accepting the plea, the defendant had waived his right to challenge the outcome. Firearms and ammunition were forever off limits. The system had spoken, calmly and clearly, and there was nowhere else to stand. This is instant karma in slow motion. No shouting, no theatrics, just the weight of the law settling in. Finally, the judge looked past the paperwork and spoke directly to the man. Age was asked. The answer came: 47. Then the warning landed, blunt and unforgettable. If you keep doing what you're doing, you will spend the rest of your natural life in prison. It wasn't anger, it was certainty. A last chance framed as truth, not mercy. The courtroom didn't gasp, it went still. In that silence, the lesson was unmistakable. Procedure can feel safe. Confidence can feel earned, but consequences don't care how calm you sound. Justice arrived without spectacle, and it stayed. For viewers, the legal takeaway is simple and severe. Waivers speed cases, stipulations streamline proof, and pleas trade uncertainty for certainty. Yet certainty can be devastating when records, enhancements, and firearm prohibitions collide. Judges must admonish, and defendants must listen. This case shows how quickly multiple files merge into one outcome, how silence replaces arguments, and how a single hearing can redraw an entire life trajectory forever without second chances.